School Bus Association welcoming you all. We've got a lot of folks coming on. I just want to make sure if someone could send me something in the question box or something that says you can hear me, I'd appreciate it. Or a chat of some kind. All good. Thank you, folks. Yeah, wow. Okay. Thank you, everybody. I appreciate that. I ended up with about 15 or 20, and so I appreciate that. All right. Well, good morning, everybody, and I want to welcome you to our START webinar on COVID-19 and school bus contractors. First of all, we hope all is well with everybody and everyone is staying safe and doing their best during what really can be described as extraordinary times. We have some folks who are logging on, so I'm going to get started to remind you all that we have muted all the participants on the call because we have an exceptionally large audience for this webinar. If you are going to ask a question, which I'm sure you may, we have the Ask a Question function that you'll see on your dashboard. So we would ask that you would submit them that way, and toward the end of the webinar, Rich Kelly, who is our presenter, will be happy to answer all questions that come our way that we can get in. We'll try to do our best to get all the questions answered within the time we have. Also, this webinar will be recorded, and a link will be made available to everybody. You will also get the handout for the presentation, or a link to the handout, when we send out the post webinar survey. So you will get a copy of this. Before we get started, or with Rich, before we bring Rich on to the screen here, I wanted to give everybody a quick update of what is happening on the Pennsylvania side and what PSBA is doing with regard to our advocacy efforts to push our message out to legislators and the Wolf administration regarding our industry's need to keep full transportation funding ongoing to contractors for 180 days. Quick update for everyone. So on March 17th, we were supposed to have a lobby day in Harrisburg. Obviously, that was canceled, but we took advantage of the time and appreciate the work with our partner with Kim Sokolowski, our partner over at Buchanan, Ingersoll and Rooney, to schedule a number of phone conferences with key legislators and their staff. This included House and Senate leadership, along with chairs of the Education, Transportation, and Appropriations Committees. We shared with them our issue paper that we have developed and that we did send along to members, and we emphasized the need to maintain full pupil transportation funding during the 180-day school year. The legislators we spoke to thanked us, said our input was extremely timely as they are working on these issues right now. They did ask and encourage us that we need to have members, those of you out there at the grassroots, contacting your legislators. As far as we know, there is no sure thing. We do know when dealing with the legislature, we know they are aware of our issues, but we really need folks to continue to contact their legislators, contact their superintendents, and so we need your help. To that end, following this webinar, a call to action is going to be sent out to all the members. That's going to include our updated issue paper, along with a sample letter you can send to your superintendent and a sample letter that you can send to your legislators. If you've missed, again, we'll be sending out this call to action. Again, we've been encouraged to contact them and get them in support of what we're what we need. I will tell you that yesterday we did send a letter to the Secretary of Education, Pedro Rivera, asking PDE to direct school districts to continue full funding for the 180-day year as well. Copies of that letter was also sent to chairs in the House and Senate Education Committee, along with legislative leaders. We're going to continue on our end to work and press the administration and legislators on this issue. Watch your emails for any updates. If you are not already receiving electronic communications from PSBA, please get signed up, and that's as easy as just contacting Christina or myself via email. I also want to remind you that we have set up a section on the website with our helpful link section, which you can find in the newsroom section of the site, that has links to information on COVID-19. It's certainly an extraordinary time. Things are changing and evolving quickly. Please, we will Watch your emails. We will keep in touch as is needed. So with that being said, I am really pleased that we have Rich Kelly on the call here. You all know Rich from RC Kelly Law Associates. I'm going to turn this over to Rich now for his presentation. Rich, thank you so much for being here.
And thanks, Mike. Great participation. As anticipated, this is a once in a lifetime, hopefully, event. We had also good participation in a similar call yesterday with the National School Transportation Association, but you guys are actually getting information hot off the presses, because I'm sure that everybody saw that last night President Trump signed the Families First Coronavirus Response Act, which provides some significant changes. So just so that you understand, all of this stuff about the Families First literally came out overnight. I've done a read of the 121 pages and tried to summarize it here. So take this all with that perspective. I've made it as complete and as accurate as I can, but stay tuned for updates. I wanted to start off at the end, actually. The Families First Act primarily makes modifications of the FMLA Act to make it apply to smaller employers and also to provide other benefits. But the important part is that the benefits that are being provided by employers, that is, including smaller employers, are really being offset by quarterly tax credits. So I'm starting at the end so that nobody jumps out a window or anything like that. Employers will be getting tax credits against their quarterly taxes for sick leave wages that are now required by the Families First Act, and for qualified family leave wages that are required by the Family First Act. The idea here is that, as employers, you set aside the dollars to pay your quarterly taxes, and these, my understanding of it, payments that you are now required to make for sick time and paid leave are going to be an offset to those quarterly taxes that you pay. So bear that in mind while we talk about what changes were made, and we'll start here up at the beginning. You'll get a copy of this, so there's no need to write it down, and this is an actual link to the whole 121-page act. It was written by the House of Representatives, approved by the Senate, and signed by President Trump. What it does is it changes the eligibility and the requirements under FMLA to include sick time payments and family leave payments. It also changes the qualifying events to be not only caring for sick family members or caring for yourself when sick, but also in the event of a school closure triggered by a health emergency. So the triggering events now include a 5-day or more closure of schools, and it provides benefits, various benefits, to households with at least one eligible child. Now, that one eligible child is typically something that applies to things like nutrition waivers and things like that. You can see I haven't written a lot about them. These are generally continuations of programs providing low-income families with lunches and nutrition. I'll write more on that, but I wanted to focus on the changes that are going to be most relevant to contractors, and that is a couple of changes to the FMLA. The Act and these changes are effective through December 31 of 2020, so through the end of the year. The employee tenure, which used to be 1,250 hours, has been changed, and the definition of employer has been changed. So employees get eligibility by being employed for 30 calendar days, and the definition of employer has been changed to any person engaged in commerce or an industry affecting commerce who employs fewer than 500 employees. Now, I'll be candid with you, I'm a little muddy on on this definition, and that is literally, you can see that that is in quotes, okay? There was a tailing quote on there, but that's the actual quote from the language. It replaces what used to be 50 or more employees requirement and 1,250 annual hours. So stay tuned for more on that. I think the real point is that it's going to include all employers. The employee eligibility has also been expanded. As explained, it used to be for caring for yourself while sick or caring for your family while sick. It has now been expanded to include, to cover an employee who is unable to work or telework due to a need for leave to care for the son or daughter 18 years of age of such employee if the school or place of care has been closed, or the child care provider of such son or daughter is unavailable due to a public health emergency. So there are exceptions written into it, and this would be not a statutory exception, but a regulatory exception. As you know, after the legislature passes a statute, the regulators, U.S. Department of Labor and others, enact statutes that typically provide greater detail. They've said in the statute that the Secretary of Labor is permitted to exempt small businesses with fewer than 50 employees from the requirements when the imposition of such requirements would jeopardize the viability of the business as a going concern. That's as much definition as we have now. I anticipate, or I know, that the regulators will be writing regulations that make that effective. What does that exactly mean? I think that's to be determined. The important part of this is the first 10 days of leave, an employee may use the existing employee's paid time off benefit, if any, but the first 10 days are unpaid. After 10 days, an employer must pay no less than 2/3 of the employee's regular pay, but no more than $200 per day and $10,000 in the aggregate. Basically, that's 50 days at $200 per day, or 10 5-day work weeks. That's a big change. Go back to where we started. The idea is that this payment, which would kick in after leave has gone past 10 days, would be offset by your quarterly tax burden. Now, I know from yesterday's discussion and from discussion with many contractors, there are many contractors that have committed to make these payments or committed to make some payments. So I think that we'll probably be looking to kind of back into that. One of the other changes under FMLA is Emergency Paid Sick Leave Act. And what this does is that an employer is required to provide each employee with paid sick time to the extent that the employee is unable to work or telework due to the need for leave for these reasons here. They're subject to a local quarantine or isolation order. The employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. The employee is experiencing symptoms of COVID-19 and seeking a medical diagnosis, or the employee is caring for an individual who's subject to one of these things above. So in terms of paid sick leave, how specifically that's going to interact with the requirement to continue wages during leave, I think is going to be something to be determined. As I said, right now, regulations will make this more clear, but in the meantime, I think that we're going to have to do the best we can to be prepared when the 10-day time frame of unpaid leave is over. I don't know how this is going to interact with unemployment compensation. I know that drivers, aides, employees that are out of work because of the school shutdown are applying for unemployment. We will talk a little bit more in this presentation how the payment of partial W-2 wages to a certain extent won't diminish unemployment benefits, but it is my understanding in Pennsylvania that generally unemployment pays for 60% of the wages up to a certain limit, and that the employee can earn up to 40% of W-2 wages without that being affected. So we'll talk about that in a little bit. Tax credits, we talked about these payments that are now going to be made by employers can be offset by tax credits. That is as much as I could kind of get from my reading here this morning. Stay tuned for more on that. There are sections below that were written yesterday before this was passed, and I put those in blue so that we can kind of understand that they're in play, and a lot's going to be changing on that. But let me go to what was really the number one question yesterday in yesterday's presentation, because the Families First Act had not yet been passed. The biggest question has been, what about loss of revenue? How am I going to get past that? Right now, we're recommending that all contractors reach out to their school districts and that they ask for continued payments. We recommend you do this even if you don't have guaranteed days in your contract, okay? So if you don't have guaranteed days, don't let that stop you from making the request. We're aware of many schools that have already agreed to continue payments to contractors, and that's taken the full gambit of shape. Some of them have committed to 100%. Some of them have asked for a reduction based on the amount of fuel that's not being burned. Some of them have negotiated a percentage based on fixed costs. I've seen that kind of all across the board. We got some sound on there, so if you're not muted, please do mute. So what we do have is that is kind of all over the board. We do have 2 states that have already taken action to continue funding from the state to the schools. Or hello, can anybody hear me now? All right, I'm not sure what that technical problem was, everybody, and I apologize for that. But we are back. Can you tell me where I left off, where you stopped hearing me, Grace Kelly? Lost revenue. Then let's pick up with lost revenue. Thank you very much. Okay, so lost revenue is being done case by case, everybody. I'm hopefully not repeating myself, but we have had the state of California and the state of Illinois commit to continuing to fund transportation, and that's taken 2 forms. California has done it by legislation. Illinois has done it by a directive from the state superintendent of schools. And we're pushing for that in Pennsylvania. Even in those areas, though, it is still case by case. The idea here is that schools obviously are reluctant to make the payments because they say that they are stewards of the public money and I can't pay for services I don't get. On the other hand, we do have the idea here that money that is already in the pockets of the schools, if they are paid to the contractor and the contractor commits to pay the driver's employees, those are employees that will not be making unemployment claims. So don't let the absence of a guaranteed days language in your contract stop you from making the request to your school. We have had schools in Pennsylvania that have made the commitment to make those payments. That's taken many forms. Sometimes they've asked for a reduction for the fuel that's not being burned. Sometimes they have just negotiated a percentage, 90%, 70%, whatever it is. That may be based on fixed costs or on other things. So what we do is we suggest that you make those calls to the extent that you are shut out or told not that you're not going to be paid. Let us know. That is the PSBA and RC Kelly, because we can help you advocate and we can provide you with information about what's happening in other areas that will give them a little bit of relief and coverage in terms of making that. So if you get those responses, again, those are your best and strongest arguments there. Some of the other questions that have come up, what about bus cleaning and costs of bus cleaning? You should reach out to your school district on this part as well too. At some point, we will be back to school and those buses will need to roll again. What we had started to recommend was that if the school is making plans for deep cleaning of the building, Contractors should offer to bring their buses to the school location so they can be cleaned at the same time. And I would make that offer as a not a request, but a, hey, we'll do this, it makes sense. And if they're the ones that say, no, we're not going to do that, make them be the bad guy. Be aware that cleaning is perhaps not as simple as it sounds, and we recommend that you seek qualified guidance. And there are some links that are provided at the end of this that can tell you about how cleaning can be done. Be also mindful of inherent risks that may be based on age or health condition. You're required to protect employees from exposure, so requiring them to clean a surface that you believe may be infected might not be something that is appropriate under the circumstances. The other thing to remember is that, from what we know about COVID-19, the virus remains active on certain surfaces for limited times. So what that means is that your buses that are sitting idle right now, just by sitting idle right now, as long as they're not disturbed, may actually not need to be cleaned when this is all over. So the advice that we're giving you is keep track of what buses are either in service for other purposes or are perhaps being serviced in the mechanic shop or things of that sort. When you reopen, it may be important to be able to say with certainty, those 50 buses haven't been touched by anybody, or these 3 buses were in the shop for service, that sort of thing. So be aware of that. One of the other questions that we have coming up is loss of revenue and extra expense. Is that covered by business income insurance? I've spent a significant time talking with Linda Neff at Keystone Insurance and over the various exclusions and definitions and things out there. The bottom line is that revenue loss and extra expense from these school cancellations are generally not covered under standard business income policy because it typically provides coverage that is incident-based, a fire to your facility, storm damage, something that prevents you from using your operations. Understand also that there are exclusions for losses caused by virus or by bacteria that may also apply. But the insurance issue is evolving at the regulatory level. It's possible that special relief or special rules could be promulgated, but again, it is not certain. What we recommend is that if you believe you may have a potential loss, you should report that loss to your insurer and let them make the investigation and the decision. So in terms of insurance coverage for it under traditional forms, I would not plan on getting business income insurance coverage there. One of the questions, can a contractor employees get unemployment compensation during the school closure? And the answer to that is that employees who normally apply for and receive unemployment should be eligible for unemployment during this school closure, subject to the requirements in your particular state. You should follow the same procedures that you would normally follow for a summer winter break. That is letters of scheduled return to work and things of that sort. Now, a lot of the school unemployment rules have been relaxed because they are not requiring the search for work during these times. So you may or may not need those letters. I know we've helped a few contractors with them. The other question that comes up is payments that go to drivers. So the idea here is what about fixed costs and continued payments to drivers and other employees during a school closure. Generally, contractors who have received commitments of continued payments from schools have made commitments of continued payments to drivers, aides, and other employees that are working for that school. At this time, as stated, commitments are being done on a case-by-case basis. So what that means is that you may have employees in the same company that are differently situated. So if you don't have a commitment, again, most contractors simply can't continue to pay employees if they do not receive continued payments from schools. If employees are eligible for paid time off, it should be administered to your normal practices and procedures. If you're considering payments outside of a paid time off program, you should document the legitimate business reasons for your plan of payments. We have some contractors that drive for multiple schools. One or two schools have said, yes, we'll continue to pay you. One has said no. And many of those are applying the payments they receive in partial amounts across their staff so that they can retain all drivers and employees. We have others that are administering that differently for different reasons. Your decisions on points like that need to be non-discriminatory and based on legitimate business concerns. There is guidance in this document from the EEOC about that. And the important part there is that what makes sense to you right now under these very bizarre circumstances may not make sense 6 months from now or a year from now when someone is arguing that they should have been paid or should have been paid more or that the funds should have been administered differently. Whether that documentation is a memo of your own or a memo to your other owners, if it's a husband and wife, or to your other owners if you have partners, or even to your supervisors and managers explaining what you're doing. It's going to be important not to just willy-nilly make payments, but to think about it, to be sure that it is not discriminatory in its process, but based on what makes sense considering all of the circumstances and business considerations. Contractors should be aware that employees that are receiving unemployment compensation can normally receive some amount of W-2 wages without a decrease of those unemployment payments. So contractors have been backing into that figure in some situations. But again, with the changes that have come down last night and this morning from the Families First Act, that may be new math to do. So in some situations, payment of normal wages or a portion of normal wages could conceivably make the employee whole. You can document, and again, this was written yesterday, that's why it's in blue, continued payments as either a loan, advance payment of future wages, or standby compensation. That is compensation to secure the commitment of the driver to return when school reopens. In any of those cases, it's reasonable to make a payment in exchange for a driver's commitment to return to driving when the school closure is over. Documents like that should be reviewed with counsel since they may unintentionally modify an employee's at-will status. You may, make an agreement, I'll pay you this amount, X dollars a day or X dollars a week, and you understand that you'll come back and drive for me. That may modify, and that may create a contract of employment, which is something that you may or may not intend. So be aware of that. Standby compensation can also be payment for actual work performed and is generally in that situation not repaid. It may be that you have employees, some of them doing some work of some sort, and you can certainly pay them a different amount or pay them for that work to the extent that you have it. Strictly speaking, loans or advanced wages can be subject to repayment from future wages or otherwise, but there are state-by-state rules for deductions from employees' paychecks that need to be considered, and you should consider how repayment requirement may be perceived by your schools, by the community, or by your employees. Now, this is in blue because it was written yesterday. I think that we really need to look carefully at what payments are being required. I think we have a little bit of a window because certainly most contractors are on a pay period where it's a week behind, so they're probably getting a paycheck at the end of this week for the work they did last week. And so their first week of no pay is really not going to hit until the end of this coming week. A lot's going to happen between now and then, and you should consider that. One of the questions that has come up also is what about perfect attendance type programs, and a lot of contractors have those. You want to look at those on a case-by-case basis too. And the reason that I say that is they are, these programs of perfect attendance bonuses are considered wages under state law, the Pennsylvania State Wage Payment Law. So what this means is that depending on how your perfect attendance program is written, there may be accrued entitlement to previous amounts. Some of them have perfect attendance from the beginning of the year. Some of them have it reset after the winter break. The variety of these programs is pretty wide. But the reason I bring this up and the reason I'm fixating on it a little bit is the Pennsylvania Wage Payment Act is very aggressive. It allows for reimbursement of attorney's fees if an employee has to get an attorney to recover their wages, and it also allows for treble damages, punitive damages, based on the number of days pay is withheld. So again, that may not be relevant today, right now, but a year from now, is there an attorney that's going to have a meeting with your employee who says, yeah, I had a perfect attendance and I was on track for getting the bonus, and then coronavirus hit and, nothing happened? Because I have talked to contractors who have told their employees that they are terminating or ending or suspending these programs. I think you have to really be careful about what words you use and how you do that, because it may be a situation where they have right to accrued wages, and a clever attorney may turn that into an action not only on behalf of that one employee, but on all employees that may be entitled to a perfect attendance bonus. Next question, and this is really the big one because we talked about it up there before. What about FMLA has been a big question. See the section above about the Family's First Coronavirus Response Act. It applies to employers with less than 500 employees and requires a combination of paid leave and paid sick time, with employers able to claim quarterly tax credits for amounts paid. I'm going to continue through what we wrote yesterday and what we talked yesterday to the extent that some of this is still relevant. Understand that these requirements, which were in place, will still be in place after the Families First Act ends on December 31 of 2020. But again, there may be changes to that as well. Previously, eligible employees were eligible to take up to 12 weeks of unpaid leave to care for themselves or to care for family members. And the definitions of what was continuing treatment and what is a serious health condition will still be relevant, because there's going to be, again, potentially people that are ill from this or do have to take care of family members from this, not because the school is closed, but because there is an actual illness. I don't expect these to be sequential benefits, but it's certainly possible. So I think that you really need to just watch this as it comes out. There was guidance from the Department of Labor about what is or is not a serious health condition and what is or is not continuing treatment. To the extent that it's relevant, previous guidance said that something as simple as a common cold or a flu by itself was not a serious health condition or requiring continuing treatment, generally because it does not last more than 3 consecutive calendar days. So there was a 3-day trigger in there. From the terms of the continuing treatment, there was guidance from the Department of Labor saying that a visit to a doctor and a prescription that you must take over a period of days could be construed to be treatment, continuing treatment. Again, to the extent that that's relevant, it will apply to someone who is actually and truly sick. It, though, is supplemented by the Families First Act, which makes the requirement to make payments much, much more broad. Upon leaving from an FMLA leave, an employee must be restored to their original job or to an equivalent job. In the school bus world, especially for drivers, that's not a problem because we're going to need all the drivers we can get. So this was, again, something from yesterday, and that is a no-fault attendance policy. FMLA explicitly says that you're not allowed to consider leave as a penalty to a no-fault attendance policy. In other words, strictly speaking, you can't say you get no bonus or no benefit because you went on leave. But by the same token, you will be permitted to apply the bonus as it was intended, and you should seek some guidance on that. If your company is covered by FMLA, an employee receives a positive coronavirus test, that employee may be eligible, and we'll talk a little bit about the Americans with Disabilities Act. One of the other things to be aware of is that some states, specifically the ones listed here, California, Connecticut, Hawaii, Maine, Minnesota, New Jersey, Oregon, Rhode Island, Vermont, Washington, Wisconsin, and Washington, D.C., have state FMLA statutes that often are more generous and apply to a smaller employer than the federal ones do. Another point to be aware of is that there is an executive order out there that establishes paid sick leave requirement for federal contractors. So if any of your contracts are with the federal government, you should be looking at that carefully. Some of the other questions that have come up is regarding OSHA. As you know, OSHA requires you to provide a safe workplace. And what this means is best looked at by consideration to the OSHA COVID-19 website. At that website, it talks about what and how you should protect employees from exposure. And you should be aware that the regulations and case law that's already in place do recognize an employer's obligation to provide a safe work environment. The point here being that educate yourself as to not only what is required, but what makes sense for your business. Every business is different. School Bus is unique. And again, what is required or practical or reasonable for a school bus operator may not be to the letter of the law, specifically what is cited here. We're going to have to apply those in ways that make sense. Again, when we talk about health risks to employees or to student passengers, ADA and EEOC will apply to your employees. The EEOC has said that the ADA and the Rehab Act continue to apply and that they do not interfere or prevent employers from following the guidelines and suggestions made by the CDC. Okay, what this means is that you can exclude workers from the workplace, but you have to do so in an appropriate method. Employees who appear to be sick, you can send them home and they should be separated from other employees. Respiratory etiquette and good hygiene in the workplace should be followed. And as well as your employee should inform you if they have a sick family member at home. They should notify their supervisor, and there is CDC guidance on how to provide a risk assessment, or how to do a risk assessment of your workplace to determine if you have an ongoing exposure. There's a link in this document. You'll get that, and you can run through this for guidance on how to determine if, due to an exposure, either by your employee or by a family member of an employee, if you have an exposure there. We are counseling clients who have had employees exposed and confirmed tests. And again, that's a case-by-case analysis. The important thing here is that you are not prevented from doing things, but you are still required to maintain confidentiality as required by the ADA. The way that we address that is by talking in practical terms to the affected employee. Generally speaking, if you say to the affected employee, listen, we need to tell Jim, Joe, and Sally because you worked with them on this bus or that route or whatever the case is, generally the affected employee says, yes, that's fine, tell them. Strictly speaking, you're required to keep that confidential. We haven't had a situation where an employee has refused to say, yes, you're allowed to tell them that it was me. But be aware that that is something that is out there and that you need to be mindful of. Again, we went through this. You are permitted to exclude people from the workplace. You are permitted to require a return to work certification. And again, those return to work certifications may be muddy. We all know that when an employee comes in with return to work, a lot of times it's something hand scribbled on a doctor or family doctor's piece of paper, and it doesn't really address whether they can do the job or they can't. You are permitted to make inquiries, but generally you should not have that inquiry made by the direct supervisor of the employee. Ideally, it's made by either a human resource professional, a leave administrator, a manager. We make those inquiries on behalf of contractors frequently. So be aware that there are things you can ask and can't ask. Generally speaking, you can't ask about the employee's condition. So what we suggest is that you make it clear to the doctor that you're talking to what is required before you can allow an employee back. So you're not asking about their condition, but you're simply saying that our policy and or the CDC recommend that an employee be symptom-free for 14 days before they return to work. And that way you're not asking if they have been, but you tell them that I need your letter saying that that's the case. That sort of thing there. Again, you can question them, but there are various privacy issues. Workers' compensation. We've had employers ask if this would be a compensable claim under workers' compensation. Generally speaking, if the employee can show that the illness was contracted at work and in the course and scope of work, it could be compensable. Or if they could show that a particular kind of work is more likely to expose them to an infection. Think of the asbestos workers and in manufacturing. That's the very definition of an occupational disease, asbestosis and various afflictions of the respiratory system. Now, that's a pretty tall order considering what we know about coronavirus infection and how easy it is to get from various places. So their ability to say, yes, I contracted this from the bus or from the building, I think is pretty unlikely. However, if you have a concern about that, we recommend, again, that you report potential claims to your workers' comp carrier. Let them do the investigation. Let them handle the case. This is an issue that's evolving, including regulatory issues related to insurance. So to the extent that you believe you may have an exposure, certainly discuss that with your insurance agent. One of the other questions that we get periodically is, what about non-employees and negligence? Understand that if an employee claims they were injured on the job, they are prevented by workers' comp statutes from making a negligence claim against you. But if it is a student or a non-employee, perhaps a contractor or an aide who is employed by the school district, not by you as a contractor, someone of that sort could certainly make that allegation. And in some of your situations, the population of people on one of your vehicles may be very small. You have a driver, you have an aide, and you have 3 student passengers on a van. Okay? So in some of these scenarios, you may have one of those people in that chain that is not your employee say, I believe I contracted the infection from here. Now, they would need to show that the contractor acted in a negligent manner. That is, the person has to sustain injuries. They have to show that it was caused by the contractor's breach of a known duty. So the mere fact that they were breathing in your bus or in your building, and it may be likely that they contracted it from there, does not necessarily mean that you are liable. An injured or ill person would have to prove it, and any claim really should be promptly referred to your liability carrier. Be aware that there are liability and auto liability exclusions that may apply for pollution, for virus, for bacteria, fungi. Spent, again, considerable time with Linda Neff going through these, and I think it's probably a wait-and-see approach. I think a lot of these will probably be litigated, and I think they'll be litigated a year or more from now. So documentation is key, and that's where we talk about things like up until the school closures, knowing who was rostered on what buses, I think is going to be important. I believe that while the closure is underway, being able to conclusively say that certain buses were in fact not touched, they were quarantined themselves, will be relevant and valuable information. And like I said, the whole issue is there kind of evolving. Some of the other questions that have been asked, other than continued payments from schools, what other funds may be available to help me maintain operations and retain staff? I think this is one of the most important things that you can do and do right away. Contact your current lenders to the extent that you have financed equipment or even financed buildings, and ask them if they will allow you to make interest-only payments for the duration of the school closure. I am aware of many lenders who have already provided this kind of relief, but I would not expect that they're going to call you and ask you if you'd like that relief. So I think it's going to be in your best interest to reach out to your lenders and your mortgage holders and specifically ask for that. There are states that have declared a state of emergency. Federal Congress has provided funding that is being administered through the Small Business Administration. So be aware that those funds are available, and there's a link here on how you can apply for those funds as well. That is in states that have declared a state of emergency. I believe Pennsylvania has as of March 6th, and I think that declaration was winding its way through a regulatory process. So at the end of this, if Mike has anything more on that, I'll ask him to chime in at that time. Many states that have not declared a state of emergency, and if I did the math right, I think that there was the majority. I want to say 40 plus or perhaps even more than 45 have declared states of emergency. But standard financing is available, and it's cheaper than ever. But again, that may not be practical under the circumstances that we're in right now. One of the other special buckets of financing is funds that are made available for by the Center for Disease Control, and that's for responses that include disinfecting buildings, buses, and public areas. These funds are typically being made available by the federal government to the states for administration through the state health departments. This goes back to the suggestion that you find out what your schools are doing and you make your buses available for the same sort of services paid by the same sort of funds. Now, again, consider again that it may be that quarantining the buses is as effective as cleaning them. I can't tell you what the answer to that is, but I would look to qualified resources for that answer, whether it's the CDC or an organization that has been hired to do cleaning, or your school district. Ask them for guidance for what they believe is appropriate under the circumstances. This doc is posted at rckelly.com/COVID-19 update, and we will continue to update it there as things change. Be aware that your own computer may cache this document, meaning that it may save it from the last time you saw it, so you might need to clear your cache. If you believe that there might be a more updated one out there, we'll certainly make those available to members and contact either our office or the PSBA office to find that out. Resources that are available, RC Kelly Law is certainly available to help you. Some of the things that we've been helping contractors with are these interim agreements. You may have struck a deal with your school district for them to keep flows funding. We recommend that those agreements be documented somehow. Some of them are contemplating amendments to their existing contracts. Some of them are simply doing interim agreements. Some of them are exchanging emails. But if you'd like to know what yours should say or would like some eyes to look at it to say, yeah, that makes sense, feel free to reach out to us. The Pennsylvania School Bus Association has all kinds of resources available through our office and also through the website. The National School Transportation Association is also gathering information and making information available to members too. OSHA has a good website. State health departments are there. Department of Labor, EEOC, CDC. Again, a lot of these are out there and available. That took us through about an hour. We had a little bit of a technical difficulty in there, and again, apologize for that, and I'm glad that we've worked through it. I do know that Mike and Christina are collecting questions that are being typed in through the webinar program, and I have a few others that Mike received last night. So let me turn it over to Mike to see if there are questions that have been typed in.
Thanks, Rich, and thank you. This is a ton of information, and we do have a few questions, so I'm going to start with those right now. For those of you who've typed in questions, if I didn't hit right on them, feel free to, again, type me a quick message as a follow-up if we're missing the point of what you were trying to do. We're trying to get across here. So, all right, we'll start with this question, Rich. We are a small contractor. Our employees do not have any benefits, for example, paid time off. They are only paid for the days they actually work. They do, however, draw unemployment over the summer break. So I guess the question is, are they covered anywhere under here for benefits?
Yep, and I would say, yep, and I would say that this Family First Act addresses that explicit situation. There is the 10-day unpaid leave period, and again, I believe that this would, the way I read it, require up to 2/3 of their normal pay, up to $200 per day, starting 10 days after this event has taken place. And the employer that makes those payments is going to be permitted to take a 100% credit from their quarterly taxes that they're required to pay. I know that, again, because things are moving fast, those employees probably have applied for unemployment compensation. So it's possible that they may be getting checks from unemployment. I would suggest that you do some homework between now and that 10-day window. Most of the schools close the beginning of this week. So I think that really obligations under this statute are not going to hit until the end of the coming week. But find out what your employees are doing. Have they applied? Have they received any unemployment benefits? And I, off the cuff here, I think the recommendation is to do what is required of the Families First Act, but by the same token, communicate with your employees so that there's not double payments. There's unemployment, there's this benefit, there are maybe other payments that are being made as well. Other questions, Mike?
Yep, we'll keep going. So with regards to standby payments, what do you do if an employee doesn't return next year? Do you get the money back? That's
a great question, and that really kind of comes down to this particular section here. If it is a standby payment and they don't come back, then it is reasonable to request that money back, provided the document that you gave them or the explanation of payment that you gave them contemplated that. Before this Families First Act, I was telling contractors that, an agreement of some sort that they would come back and work for you when you need them, should include some kind of terms of reimbursement if they don't come back. Again, I think that this kind of changes that world. I would suggest that first you look to comply with this statute. I think that's going to be kind of a self-answering environment. And it may be that you're not making standby payments because you're paying them these 2/3. Now, while it requires the employer to keep the job secure, I haven't read anything that says it requires the employee to return to work. So it may be that you have to deal on a case-by-case basis with staffing for driving when the school is back in place. Let me make a comment on that too. I know it's going to be difficult to start up again for all of the reasons. It is my position as an attorney that if you are not able to staff, say, all of your routes, I don't believe you would be in breach, because I think that the contract doctrines of impossibility would absolutely apply. Now, that's my off-the-cuff answer, but I think that there is some contract doctrines that will provide some cover in that scenario. What other questions do you have, Mike?
Okay. What about a company what if you provide medical benefits for both your driver and medical benefits for the driver that the company pays for? I guess the question is, are you required to continue those, or?
Yes, under existing FMLA law, if they were on an FMLA leave, the employer is required to continue to pay for the same portion of the health care premiums that you paid previously. If you had a 50-50 pay, or you paid for 80%, or however you did that, while they are on a qualified FMLA leave, you're required to continue those payments. Now, the way I read this statute is that same rule would apply to this expanded FMLA coverage.
Okay.
Other questions, Mike?
Yeah, I think a negative follow-up one I had from that, if we were shut down, does this still apply to us? I believe that dealt with the same thing.
Right.
Are employees that were laid off before the Family First Act was passed eligible or covered by the act?
That's a very good question, because it's going to be a question of timing. My guess is that regulators that are making decisions about whether or not an employer has complied or not, I would expect them to make decisions in favor of employees receiving benefits. I am aware that the majority of contractors told their drivers on Friday, school's closed Monday, so go apply for unemployment, you're laid off. They may or may not have gotten letters out to their employees, but I just expect, regulators being what regulators are, and public policy being that favoring the support of families, I believe that they will probably say that you would be required to comply with the Families First Act. And again, that's just Rich Kelly talking. Stay tuned, because as we get clarification on that, we will post it.
Okay. I was asked if you could confirm whether emergency leave falls under the same financial conditions, $200 a day max or $10,000. Max of $10,000.
Yep, and the statute does give that limit. That is, they have two buckets of pay, one being emergency and family medical leave, the expanded benefit, and that's where that 2/3 of wages, $200 a day, $10,000 in the aggregate. That's where that comes from. Now, I'll be honest with you, this second bucket, which is the Emergency Paid Sick Leave Act, it is not clear to me as we speak how that interacts with the fact that you're giving them partial pay as well. I don't expect that any of these require double dipping. And in fact, there is language in the 120 pages that say double dipping is prohibited. But it almost seems to me that the amount of payment that they would be required, or that you would be required to make if they are actually sick as opposed to on a leave, is higher. This section I did not see having the same $200 per day and 2/3 limitation. But again, I read it very, very quickly this morning so that I could do this presentation. Stay tuned for that. But I believe that first and foremost, this is the figures that contractors should be focused on. If you do have someone that is actually sick and under treatment, we should probably talk about how that one employee should be treated.
Okay. Any advice for right now as far as these payments to employees? Do we sit tight? No one, one contractor writes, no one would miss a check here until April 9th. So would you suggest waiting for guidance until the beginning of April?
Yes, I would do exactly that. And I think that's good advice for everyone. And everybody's, window of, I'll call it delay for pay, is a little different. Generally speaking, the shortest of those windows I see is a week. Sometimes it's as much as 2 or more. But do the homework. Certainly talk with us to the extent that we can give you guidance on that. But be prepared, not only to make the payments, but also to provide communication to your employees explaining what you're doing, why, and how. In my experience, the lack of communication is what gets people into trouble more than anything else. So if you're going to be making either payments or partial payments, share with them how that payment is calculated. And if some component of that is for standby compensation or something of that sort, make that clear as well. And also, don't forget to consider your attendance and safety bonuses that they may have an accrued right to receive. Other questions, Mike?
Yeah, I'm going to keep rattling through these. How does the Family First Act and unemployment comp work together?
That's a good question. And I say that because the Family First Act is a federal statute, and generally unemployment compensation is a state regulatory scheme and benefit. The same way the law favors employees receiving benefits, I think that it also is mindful of avoiding windfalls or double dipping. I don't have any Pennsylvania guidance on that yet, but I really do expect that that sort of guidance will likely come out. We'll be updating this document. That's why I say the best thing for you to do now is be aware of who is on unemployment and who may not be. Be aware of who may have received payments already, and keep careful track of how each person is situated. Other questions?
All right. Yeah. Do you think now that the larger contractors have to pay the drivers, this hurts our chances to get support from the district when our contract has no guaranteed days in it?
I'm sorry, Mike. Could you say that one again?
Yeah. Do you think that now that contractors, I guess larger contractors, have to pay the drivers, this hurts our chance to get support from the district when our contract makes no mention of guaranteed days?
I am hopeful that that whole issue of the school districts paying the contractors is resolved realistically with guidance from the Pennsylvania Department of Education or the governor. I know that there are possibilities for legislative solutions, but I believe that the biggest roadblock in my experience is that the schools believe they're going to get penalized when they are audited by the Attorney General. And I think that if we can get guidance from either and when I said Attorney General, I meant Auditor General. If we can get guidance from the Auditor General or the Governor or the State Education Department, I think that'll go a long way to having some clarity. But I also do believe that it is going to be still school by school by school, district by district. It's going to be a combination of what the direction and legislation says, and also a combination of what your contract says. And the reason I say that is understand that you may have a contract that provides for 9 or 10 flat payments with a reconciliation at the end of the year. Well, I've read a lot of those contracts, and strictly speaking, a lot of those contracts don't require you to drive a bus in that month. It simply says last year's payment for transportation was X. X divided by 10 is this. I'm going to pay you that amount every month. And at the end of June, we're going to do a reconciliation. So some of those I read, they've got to pay you those amounts, whether you drive a bus or not. So again, even if you don't have guaranteed days, you may have a very strong footing to receive continued payments. And that's why these things have to be looked at carefully and case by case. Okay. Other questions, Mike?
Thank you. Yeah. Will employees be penalized via higher premiums for employees signing up for unemployment compensation benefits, or has the state made any exceptions to not increase those rates?
It's my understanding from what I read, and again, I'm reading a lot of different states, that Pennsylvania does not intend to penalize the unemployment rate of employers who have employees out on these leaves.
Okay. Yeah, and I think we have raised that question ourselves, or that issue concern as well. What if there's no cash flow to pay the 2/3 payment
That's
that is
a
required?
very good question, because I think that if it doesn't happen right away, it's likely going to happen eventually. You know, I don't. There are various protections. I don't want to say, you know, bankruptcy and things like that, but I mean, obviously that's there, but I don't want to, you know, say, gee, that's your remedy. I really believe that things like small business administration loans and other, you know, resources that are out there are going to be made available to cover extraordinary circumstances.
Right. And to your question earlier, we did send out an update to everybody who gets our member vote, and the governor did apply, as you I think mentioned, Rich, to the federal government a disaster declaration to the Small Business Administration to start triggering to trigger it, and I'm sure it'll be approved, and then folks in Pennsylvania will be eligible for various loans that are available and assistance.
Right. And understand again, and understand again, this is literally happening really, really, really fast. I've had, you know, not a lot of time to look at what's here. I know that there are various federal funds that are being made available. I know that they're being made available through a number of various ways. Take everything again that you're hearing here with a grain of salt, and look for clarification that's going to come out. You know, so we'll be supplementing this. Go ahead, Mike.
Going with those 2/3 payment, that's required by the new legislation. Could you issue the 2/3 payment that is required and consider the remaining 1/3 to be standby?
And I'm sorry, could you say that again?
So could you issue the 2/3 payment that is required under the new legislation? Could you issue that money and then consider the remaining 1/3 to be standby?
Yes, I believe that you could. You know, you could make the payment. You could make any payment that you're not required to make because of hours worked or a regulatory scheme. You could certainly make that in exchange for standby. Okay. And that's where the documents become important.
Gotcha. If a school district doesn't resume in 10 days and your districts are refusing to pay, do you still have to pay the employees 2/3 of their pay? What if the company doesn't have the funds to pay them?
Well, and again, I'm reading additional stuff in here about how they're going to fund this. You know, it is possible that there would be funds for this specifically through the Social Security Administration. I'm seeing some, and through a few others. I would again understand that what you're hearing right now is an hour-long or 2-hour-long reading of a 120-page document. So it may be that there are funds available, whether it's through the federal government, Social Security, or through others, that are going to be available like an unemployment benefit.
Right. Okay.
So, you know, again,
sorry.
Go ahead, Mike.
The 10 days you mentioned in the law, is that 10 calendar days or 10 business days?
It is 10, I believe it is calendar days. And I'd have to look at that.
Okay. If we are shut down, 100% shut down, and the employees are applying for unemployment, are we required to pay in accordance with the Families First Act and pay employees after the unpaid 10 days? A district is not paying us currently. They have said that they might be willing to loan us money that has to be paid back so we don't go under. We're currently not willing to take a loan out, but if we were to take a loan from the school district, pardon me, I'm going to have to go down further here. If we were to take a loan out from the school district, that needs to be paid back, that is not revenue. So I guess the question is, I'm running out of space here. So if you can answer that, I'm going to try to get more.
Yeah, and rather than sow too many seeds of confusion, what I would like to do is all of these things that we have collected, we are going to be putting out in an FAQ. We're going to be putting out again what the most current information on this is. Whether these payments come directly from employers and are credited against quarterly taxes. And again, you'll see the link to the actual statute itself, or whether they have set up a specific fund for like a Social Security fund or an unemployment fund or something of that sort. But it is my understanding that there is, whether it is through tax credits or through funds that are made available from the Act, that there is an understanding that the money's got to come from somewhere. I am certain that what we'll be doing is a follow-up webinar that will, kind of make this clear as it comes out. What I would say is certainly look at the Act, and we'll be working on this certainly the rest of the day. But we will, get this out and try to make these as clear as possible. Right now, I would not do anything. Okay, I would not, tell your employees they're going to get this. I would not, make plans. I would not change your course. Okay, I would see what clarification comes by the end of this week. And as you noted, and as many people know, an employee is really not going to see their first no paycheck week until the end of the coming week. So there's not really anything that needs to happen today, right now. But be aware of all of these moving parts.
All right. I got a few more, Rich. Hang in there. And then we're going to have to ask people probably to submit them via email to us. We've got a whole list of other questions that people have sent us. And we'll, as Rich said, develop an FAQ based on that. All our drivers are considered part-time. So does part-time employees fall under the Emergency Paid Leave Act, Paid Sick Leave Act? And what about full-time employees who do not currently receive any paid sick leave, only paid vacation?
If you didn't give them health care benefits before the Act, you're not going to be required to give them health care benefits after the Act, is my understanding. I don't read this to say that you're now required to give everybody health care.
Are we permitted to share this presentation with their accounting firm?
I'll tell you what, this presentation and the document that you have is really a draft document. Certainly share what you can, but consider again that it's a 1 or 2 hour read of a 120-page document. So I would, again, take it for what that's worth. Okay, this webinar was scheduled certainly before the bill was passed, and I didn't want to do this presentation without at least telling you what I was able to glean from that read so far. So, to the extent that you do share it with them, certainly give it that context.
Any idea if the 2/3 family first pay could be considered similar to severance, which is excluded from workers' comp and unemployment?
I don't. Go ahead.
So anything that's paid under the Family Benefits Act, so that goes back to the double dipping question. They will not. They won't count it. It will not be allowed to be double dipped. So yes, it kind of will act that way, but definitely not a severance.
Yeah, not as,
because you don't want to sever anybody at this point. Yeah, I'm assuming.
Yeah, you don't.
This is Grace, by the way.
This is Grace.
Sorry.
Hi, Grace. Thank you, Grace.
The other thing on that point regarding severance, generally speaking, a severance payment is a payment that is not required due to wages or law. So if you're required either by law or just by simple, an employment agreement to make a payment, it's not consideration above and beyond what you would normally be required to pay.
Even though our businesses are non-essential, are we permitted to short staff with social distancing rule keeping? If we do that, we have them fill out a form each day that they report, which indicates came willingly, not sick or exposed to anyone who is positive. Is there anything on them being allowed to do that?
I think that's a great practice. Especially to the extent that the amount of staff you have in the office is probably somewhat limited. So I think it is good to follow practices like that, to have them, number one, separated. We're working on limited staff here with many people working at home and a very limited number working in the office. And I think that going the next step of having them certify that they are not sick and they're not living with someone that's sick.
If our employees have applied for unemployment and we have confirmed that we are, so let me try this again. So if our employees have applied for unemployment and we have confirmed that we are still required, so do we still have to pay them the 2/3 after 10 days if they've already applied for unemployment and the employer has confirmed that they are laid off?
Right. And those are the kind of detailed questions that are going to require a closer look at what's here. We'll get you those answers before you have to make your next payroll. But for right now, I can't tell you that. I don't have an answer for that. Okay. I understand that, again, you've got some people on unemployment and you want to avoid a situation where they get an unemployment check and a paycheck, or an unemployment check, a paycheck, and a benefits check from Social Security, or something like that. So that's why I say, for now, I would not do anything based on this document. Okay, I would consider this for what it is, a quick read of a very complex piece of legislation with regulations that will follow that will be equally complex.
Okay. What if employees can't pay their portion of the medical insurance? Is the employer required to pay all of it to make it to keep it up?
No, and we run into that frequently. You run into that occasionally, Grace, correct?
Yeah, I'm just not sure if this statute says anything about that yet.
Yeah, under normal FMLA, if the employee doesn't pay their portion, the employer is not required to make up the difference, meaning the coverage ends.
I was asked if we could provide a template of how we should document these payments so everyone is protected.
We can certainly provide. Yeah, we can certainly provide guidance, but it's kind of like when somebody says, "Can you give me a standard release or a standard anything?" Yeah, we can provide as much guidance and as much of a template as we can, but you will need to modify anything we provide to address your specific situation.
How long do we need to continue the 2/3 payments?
Now, understand that what it says here is that payments are $200 a day, $10,000 in the aggregate. The extension period under FMLA is for those timeframes, but again, before you go down a path of making payments or things like that, let's be sure that the administration is, as described here and all of that. Okay.
Question was, our next payroll is tomorrow. Do you think we'll have any more information about the regulations before tomorrow morning or afternoon?
I doubt it, and you should probably call us. That's what I recommend there.
Good deal.
Yeah.
Yeah. Have you heard any? Well, I can answer this one.
And again, if your payroll for tomorrow is for this week that has where there's been no pay, that's one thing. If your payroll for tomorrow is for the week previous, it shouldn't be affected. So again, if you've got a payroll for tomorrow that is based on this week's work or not work, we should probably talk.
Okay. Question I got, and I can probably answer this one, is what have you heard regarding schools reopening? what can we do to advocate for the reopening of schools? At this point, that is any conversations we have come back to us that PDE and the administration are all just watching to see on guidance from CDC, and are also looking at the situation in the state. So at this point, we've just been asked to keep in the loop about what they're thinking, but we are waiting to hear back from the department and from the Secretary of Education, the governor. Another question was, is there any indication if school will be made up? Again, we're waiting on that as well. They've been discussing how not to penalize schools if they can't meet the 180 days, but no discussion has been held at this point whether or not they'll be looking to tack on those days at the end of the year. So last thing we heard, and we're in the process of setting up some meetings with PDE, but we've also been talking with our friends at PSBA and the School Superintendents Association, et cetera, is they're still working on those things. They've made no decisions about how to proceed with the school year once they resume.
Right.
A question was, how can the Family First Act be enforced if the school district or intermediate unit does not pay us during these closures?
Again, I've got to tell you that the document that you've got has a link to the actual bill that was passed and signed. There's going to be regulations that come out. There are funds that are being administered by the federal government, and I see in a lot of this is going to include not only enhancements to the unemployment compensation system, but also to the Social Security Administration system. So I don't have any more detail. Those are good questions that everybody is going to get answers to, but it's the sort of thing that I think is going to have to evolve as we go forward here. So I don't, as we sit here, have an answer for you.
Okay. Only a few more, Rich. Hang in there. Our drivers are laid off for lack of work, not because they meet one of the Family First FMLA standards. So would they qualify for the 2/3 pay?
Yes, if they're out because of COVID-19. Right.
Okay.
If you look at the triggering events, okay, the triggering events include the closure of the schools for a health emergency. In other words, the Family First Act modifies what a triggering event is.
Okay. Okay. Is anyone else running into questions about drivers not being paid, yet those who are office staff and mechanics are still getting their compensation? I guess that's just a question about, or is anyone else running into that? And we don't have an open mic, so I imagine that that's not uncommon with some contractors, that they do have some folks working right now.
That's where I say you've got to document the legitimate business reasons for what you're doing. You may still need your office staff because they're dealing with issues like this and payroll and all of that kind of stuff. You may still need your mechanic staff because you've got buses in various places and you need to secure them and park them and things of that sort. So it to the extent that it makes business sense for those people to be employed, but for a driver to not be employed, document it, write it down. Whether you're keeping a daily journal or whatever the case is, like I said, what makes sense today and why you did things today are clear today. They may not be clear a year from now.
Okay. Okay. What is the definition of regular pay for a school bus driver since they have various weekly amounts?
There's a calculation in the Act that addresses partial pays. Generally, they look at a 2-week average. But again, that's the kind of stuff that we will clarify as we go forward.
And it will function the same way unemployment functions. So they're already doing this for school bus because you all get unemployment during the summer.
Right.
So at least they are used to our pay practices.
if and I say if PD clarifies they will pay 100%, are we obligated to pay the drivers for the time off?
For the time that the school is closed?
I assume that's what's being asked here, yes.
The modification of the FMLA is as we described it, which is...
No, the question is if the school pays the contractor, is the contractor required to pay the drivers?
I haven't seen anything that makes that requirement, but I think that it would be hard to explain why you haven't paid your drivers if you've been paid by the school, just as a practical consideration. What I think we kind of need to do here is I actually do have a 1 o'clock that I'm supposed to be involved in. So I'd like to collect all of these and update our FAQ document so that we can answer these questions and provide even greater direction and things of that sort. Now, understand, I don't recommend that anybody right now, today, make non-reversible decisions about who's being paid and what's being paid and all that kind of stuff. I would wait for further guidance. Okay, do not make a decision based on a very brief review of a very long statute, so that we could have this discussion.
And if you want to talk specifically about your situation, give us a call.
Right.
Yep.
We can help.
And we can take the remaining questions we have and fold them into the FAQ that I know we will be putting out. So I'll have those here. I've only got a few others, and we'll get those onto the FAQ for everybody.
All right. Excellent.
Wow. Rich, I can't thank you enough. Thank you all for your help, for your participation. We are going to adjourn. This webinar will be recorded. And we will give everyone the notification. You're going to email from us when it is up and on the website. And again, I urge everybody, if you're not getting our communications by electronic, please let us know. We will be looking to schedule follow-up webinars as we get further information collected that we believe will help everybody. So just stand by and watch your emails. And again, Rich, thank you very much. Grace, thank you for chipping in there. And we look forward to talking to everybody soon. Keep in touch with us if we can be of any assistance. Thanks again.
All right. Thank you.
I'm going to go ahead and return it. Thank you.